In March 1857, the Supreme Court of the United States handed down a decision that was supposed to settle one of the most divisive questions in American life. The question was simple. Could a black man be a citizen of the United States? The court's answer was no. Not this man, not any black man, not ever. Chief Justice Roger Taney wrote that black Americans had no rights which the white man was bound to respect, that they were property, that the Constitution had never intended to include them and never could. The decision was called Dred Scott versus Sandford, and instead of settling the question, it made the Civil War inevitable. 4 years later, 620,000 Americans were dead. 11 years after Dred Scott, the country ratified a constitutional amendment designed to do one specific thing: make that decision impossible forever. The 14th Amendment. 21 words that for over 150 years have guaranteed that anyone born on American soil is automatically a citizen. 21 words that right now, in 2025, in federal courts across the country, are being challenged, reinterpreted, and argued over with the same intensity as anything that has happened since 1868. This is the story of how America went from a country with no answer to the citizenship question to a country that wrote its answer in the Constitution after one of the bloodiest wars in human history, and why that answer, after 157 years, is still not settled. The men who wrote the United States Constitution in 1787 were, by most measures, extraordinarily careful thinkers. They spent 4 months in Philadelphia arguing over every clause, every word, every punctuation mark. They designed a system of government so precisely balanced that 2.5 centuries later, most of it is still functioning. And then they completely avoided answering who was actually a citizen. The word citizen appears in the Constitution 11 times. The requirements for who can be president, who can be a senator, who can serve in the House of Representatives. All of them use citizenship as a prerequisite. But nowhere in the original document did the founders define what citizenship actually was or how you got it. This was not an oversight. It was a choice, a deliberate, calculated decision to leave the question unanswered, because answering it honestly would have required confronting slavery directly. And in 1787, the men in that room were not prepared to do that. The compromise that produced the Constitution was, at its core, a deal between states that permitted slavery and states that did not. The Southern states had made it clear, if the Constitution moved against slavery, they would not join the Union. The Northern states accepted that the price of a unified country was silence on the question of who was a person and who was property. The 3/5 compromise, counting enslaved people as 3/5 of a person for the purpose of congressional representation, was the most visible expression of that deal. Enslaved people counted toward Southern states' political power in Congress, but they could not vote, own property, or claim any of the rights that political power was supposed to protect. It was a contradiction written directly into the founding document. The citizenship gap was equally significant and far less discussed, because what it meant, practically, was that the new country had no unified rule for who belonged to it. So what did the new country actually use to determine citizenship? The answer was a patchwork. States set their own rules. Federal courts applied English common law, which included a doctrine called jus soli, the principle that being born on the territory of a country makes you a subject of that country. Under English law, this had been the standard for centuries. Under American practice, it was applied inconsistently, informally, and in the case of black Americans, essentially not at all. Free black men in some northern states could vote. In most southern states, free black people faced a maze of restrictions so comprehensive that the idea of citizenship was largely theoretical. In Virginia, free black people were required to carry documentation proving their status at all times. In South Carolina, they were legally classified as a separate category of person, neither slave nor fully free. In Mississippi, they were prohibited from settling in the state without special permission. For the 4 million people held in slavery across the South, the question of citizenship was not merely complicated, it was not asked. There was also a second doctrine running parallel to jus soli. That doctrine was jus sanguinis, citizenship by blood, by parentage. The idea that what mattered was not where you were born, but who your parents were. The Naturalization Act of 1790, the very first citizenship law passed by Congress, established that free white persons of good character could become naturalized citizens after 2 years of residence. The word white was right there in the statute, not implied, not interpreted, written. For the first 82 years of American history, the law on naturalization explicitly excluded non-white immigrants from ever becoming citizens, regardless of how long they had lived in the country, how much they had contributed to it, or how many American-born children they had raised. I mean, think about that for a second. A country founded on the principle that all men are created equal, whose naturalization law contained the word white as a legal requirement from its very first year of existence. The founders resolved the tension between that founding principle and that founding reality by simply not looking at it directly. Jefferson wrote that all men are created equal and owned 600 people over the course of his lifetime. Madison helped design the system of checks and balances that protected individual liberty and helped pass the 3/5 Compromise. These were not stupid men. They knew exactly what they were doing. They made a calculation that union was worth more than consistency, and they left the contradiction for a future generation to resolve. That future generation resolved it at gunpoint. But here is what matters before we get to the Civil War. The legal gap the founders created was not neutral. It did not leave the citizenship question open for anyone to fill in however they liked. In practice, it left that question to be answered by the states, by the courts, and by the prevailing social structures of a deeply unequal society. And those structures consistently answered the question the same way. By the 1850s, the pressure behind the citizenship question had built to the point where someone was going to force it into court. The abolitionist movement was growing. The conflict over whether new states entering the Union would be slave or free was reaching a breaking point. Every compromise that had held the country together since 1787 was fracturing. The person who forced the question into court was a man named Dred Scott. Dred Scott was born into slavery in Virginia, probably around 1799. He had no last name of his own. The name Scott came from his enslaver, Peter Blow. In the 1830s, Scott was sold to an army surgeon named John Emerson, who took him first to Illinois, a free state, and then to Fort Snelling in the Wisconsin Territory, where slavery was prohibited under the Missouri Compromise of 1820. Scott lived in free territory for the better part of a decade. He worked there. He married a woman named Harriet Robinson there, herself enslaved, whose ownership was transferred to Emerson so the couple could remain together. They had children in free territory. By the laws of Illinois and Wisconsin, they were free. Slavery could not legally exist where they were living. Then Emerson died in 1843, and his estate, including Scott and his family, was transferred back to Missouri, back into slave territory, back into the legal status of property. In 1846, Scott sued for his freedom in Missouri State Court. His argument was the one his lawyers had developed carefully. He had been taken to free territory. He had lived there. He was free by operation of law. His return to Missouri could not re-enslave him. Missouri courts had actually ruled this way before, in the principle known as once free, always free. The case took 11 years. Scott won at the trial court level, lost on a technicality, won again on retrial, lost again on appeal at the Missouri Supreme Court, which reversed its own prior decisions and ruled against him. His lawyers then maneuvered the case into federal court and eventually into the United States Supreme Court. Chief Justice Roger Taney was 79 years old when he wrote the Dred Scott opinion. He was a Marylander, the son of a tobacco planter, a former slaveholder himself who had freed his own enslaved people, and a man who believed with complete sincerity that the institution of slavery was embedded in the Constitution, and that any federal interference with it was both unconstitutional and dangerous to the Union. He had been Chief Justice for 21 years. He had written important opinions protecting civil liberties in other contexts. He was not a one-dimensional figure. He was a man of genuine complexity who held a view on slavery that was, by any reasonable measure, catastrophically wrong, and who had the power to make that view the law of the land. The court could have ruled narrowly. It could have simply said that Scott's status was governed by Missouri law, returned him to slavery under state authority, and closed the case. That would have been a terrible outcome for Scott, but it would not have reshaped American constitutional law. Taney chose not to rule narrowly. His opinion ran to 55 pages. He addressed not just Scott's individual case, but the entire question of black citizenship in America, and he addressed it in a way he clearly intended to settle permanently. Taney's central argument was that black Americans, free or enslaved, were not citizens of the United States and could not be made citizens by any act of Congress, because the founders had never intended to include them in the political community the Constitution created. He wrote that at the time of the Constitution's ratification, black people had been regarded as beings of an inferior order, with no rights which the white man was bound to respect. They were not citizens. They were not part of the people in whose name the Constitution was written. They could not sue in federal court. Scott's case had to be dismissed for lack of jurisdiction. And then Taney kept going. He also ruled that Congress had no constitutional authority to prohibit slavery in the territories. The Missouri Compromise of 1820, which had prohibited slavery north of the 3630 latitude line and had held the country together for 37 years, was unconstitutional. Void. Had always been void. That was the part that detonated the political world. People thought they had the full picture. They were wrong. Because the deepest implication of Taney's ruling was not about the territories. It was about citizenship itself. If black Americans, including free black men who had been voting in northern states for decades, were not citizens, then the entire legal status of approximately 500,000 free black people across the country had just been erased by judicial decree. 500,000 people, many of whom had been born in the United States, had lived their entire lives in the United States, had fought in its wars and paid its taxes, had now been told by the highest court in the land that they had no rights the government was bound to respect. The reaction was volcanic. Frederick Douglass, speaking less than 3 months after the decision, called it a genuine motivator for the anti-slavery movement. He argued that the decision's very extremism would accelerate the cause of emancipation, because it made visible what abolitionists had always known, that slavery was not a regional peculiarity that could be contained, but a national institution, with national legal backing that reached into every courtroom in the country. Abraham Lincoln, then a lawyer in Illinois preparing his Senate campaign, gave his most detailed analysis of Dred Scott in a speech in Springfield in June 1857. He called it part of a political conspiracy to nationalize slavery and argued that the only remedy was political: elect different people, appoint different judges, reach different conclusions. Lincoln lost his Senate race. 2 years later, he won the presidency. Confederate artillery opened fire on Fort Sumter, South Carolina, on April 12, 1861. And when the war that followed finally ended, the men who had won it were determined that Dred Scott would never be possible again. The Civil War ended on April 9, 1865. 6 days later, Abraham Lincoln was dead. By December of that year, the 13th Amendment, abolishing slavery throughout the United States, had been ratified. But the radical Republicans running Congress understood that abolishing slavery was only the first step, because the southern states, even in defeat, were already responding. Before the end of 1865, Mississippi and South Carolina had passed what became known as the Black Codes, laws so comprehensive in their intent to replicate the conditions of slavery through legal rather than physical force that they shocked even many Northerners who had not been strong advocates for black rights. Mississippi's Black Codes prohibited black people from owning farmland in towns, required all black workers to have written proof of employment or face arrest for vagrancy, and established that black children could be apprenticed without their parents' consent to white employers. South Carolina's version required annual labor contracts, restricted black people from working in any occupation other than farming or domestic service without a special license, and set penalties for breaking labor contracts that included forced work without pay. The 13th Amendment had freed 4 million people. The Black Codes were a systematic legislative attempt to return them to economic servitude and physical control through the authority of state law rather than private ownership. Congress responded with the Civil Rights Act of 1866, which declared that all persons born in the United States, regardless of race or color, were citizens and possessed equal civil rights. President Andrew Johnson vetoed it. He argued it was unconstitutional, that it interfered with states' rights, that it went too far. Congress overrode his veto. The first time in American history that a major piece of legislation became law over a presidential veto on a question this fundamental. But the radical Republicans understood that a statute was fragile. A future Congress could repeal it. A future president could refuse to enforce it. A future Supreme Court could strike it down. What they needed was something that could not be undone without amending the Constitution itself. They needed the 14th Amendment. The man who took the lead in explaining the Citizenship Clause to the full Senate was Jacob Howard of Michigan. Howard was meticulous and precise, the kind of man who understood that the words he chose would be interpreted by courts for generations. When he introduced the Citizenship Clause on the Senate floor on May 23, 1866, he did not just read the text. He explained it. He told his colleagues what subject to the jurisdiction thereof meant and, crucially, what it did not mean. It would not, he said, apply to persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States. But it would, he said, include every other class of persons. That explanation, those specific words, they would become the epicenter of the constitutional debate that still rages today. At the time, the debate in Congress focused on more immediate questions. Would the amendment apply to Chinese immigrants in California? Senator Edgar Cowan of Pennsylvania argued that it would, and that this was a problem. Howard essentially confirmed that yes, children born to Chinese immigrants in the United States would be citizens. The Senate voted for the amendment anyway. The amendment passed the Senate 33-11. It passed the House 138-36. It was ratified on July 9, 1868. The Citizenship Clause reads, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." 21 words. 4 of those 21 words would define the next century and a half of constitutional argument. Subject to the jurisdiction thereof. The men who wrote the amendment thought they had been clear. Diplomats as children, who owed formal allegiance to a foreign sovereign under treaty arrangements, were out. Native American tribal members, who existed in a separate sovereign relationship with the federal government, were out. Everyone else born on American soil was in. But Congress in 1868 was solving the problems of 1868. They were thinking about freed black Americans, about the black codes, about making Dred Scott constitutionally impossible. They were not thinking about what would happen 30 years later when a young man named Wong Kim Ark would try to return home to San Francisco and be told he was not American enough to come back. Wong Kim Ark was born in San Francisco, California, in 1873. His parents were Chinese immigrants who had come to California during the Gold Rush era, part of the wave of Chinese laborers who built the Transcontinental Railroad, worked the California gold fields, and helped create much of the infrastructure of the American West. His parents were permanent residents. They ran a business in San Francisco. They had lived in the United States for years, but they were not citizens, and under the Naturalization Act of 1870, they could never become citizens. Congress had extended naturalization rights to people of African descent in 1870, but had deliberately excluded Asian immigrants. The law was explicit: Chinese people could not naturalize. Wong Kim Ark, however, was born in San Francisco, on American soil, under a natural reading of the 14th Amendment that made him a citizen. In 1882, 9 years after Wong Kim Ark's birth, Congress passed the Chinese Exclusion Act. It was the first and only federal law in American history to explicitly ban immigration by a specific ethnic group by name. Chinese laborers were prohibited from entering the United States. Chinese immigrants already here were barred forever from becoming naturalized citizens. The law was supposed to last 10 years. It was extended, made permanent, and remained on the books until 1943. In 1894, Wong Kim Ark traveled to China to visit his parents, who had returned there. When he sailed back to San Francisco, customs officials refused to let him land. Their argument was that he was not a United States citizen. His parents were Chinese subjects, permanently ineligible for naturalization. He was to be returned to China. Wong Kim Ark retained lawyers and sued. He was held on a steamship in San Francisco Bay while the legal proceedings worked their way through the federal courts. The case reached the Supreme Court in 1897. The question before the court was as precise as a constitutional question can get. Does a child born in the United States to parents who are Chinese subjects, permanently domiciled here but ineligible for naturalization, acquire citizenship at birth under the 14th Amendment? The government argued no. Its position was that subject to the jurisdiction thereof required something more than mere physical presence. It required a form of complete political allegiance that Wong Kim Ark's parents, as subjects of the Chinese emperor, could not provide. Their son, born in San Francisco, was therefore not subject to complete U.S. jurisdiction, and was therefore not a citizen. The court ruled 6-2 in Wong Kim Ark's favor. Justice Horace Gray, writing for the majority, spent 50 pages tracing the history of birthright citizenship from English common law through the drafting and ratification of the 14th Amendment. His conclusion was clear: a child born in the United States to parents permanently domiciled there was a citizen by birth. The parents' ineligibility for naturalization was irrelevant. The parents' national allegiance was irrelevant. Birth on American soil was the operative fact. If you're wondering how the federal government could try to deny citizenship to a man born in San Francisco, so is everyone who reads this case today. The two dissenting justices, Chief Justice Melville Fuller and Justice John Harlan, offered an argument that deserves attention because it is the argument that resurfaced in the 21st century. Fuller argued that subject to the jurisdiction thereof meant subject to complete political jurisdiction, not merely being present on U.S. soil and subject to American laws. Complete political allegiance, the kind a citizen owes to a sovereign. Wong Kim Ark's parents, as subjects of the Emperor of China, owed their political allegiance to a foreign power. Their son, born in San Francisco, was subject to American jurisdiction in a territorial sense, but not in the complete political sense the 14th Amendment required. Fuller and Harlan lost, 6-2. But the dissent did not disappear. It went into the legal literature, cited in law review articles, picked up by scholars, kept alive by people who believed the majority had read the amendment too broadly. For most of the 20th century, birthright citizenship was not a major political controversy. Wong Kim Ark was settled law. The 14th Amendment meant what it said. Children born in the United States were citizens. The debate came back in the 1990s, driven by a set of facts the framers of the 14th Amendment could not have imagined. By that decade, illegal immigration from Mexico and Central America had become one of the most contested issues in American politics, and a group of immigration restrictionists began asking a question that had seemed answered for a century. Does the 14th Amendment really grant automatic citizenship to children born on American soil to parents who entered illegally? The subject to the jurisdiction thereof argument came back to life. The modern case for restricting birthright citizenship rests on one central claim. Subject to the jurisdiction thereof does not mean merely being physically present on U.S. soil and subject to American law. It means owing complete political allegiance to the United States. And undocumented immigrants who entered without legal authorization do not owe that kind of allegiance. Their presence is not authorized. Their legal relationship to the American state is contested by definition. Therefore, their children, even if born in the United States, are not born subject to U.S. jurisdiction in the complete political sense. And therefore, under this reading, the amendment does not automatically grant them citizenship. The scholars who hold this view are not fringe figures. Peter Schuck and Roger Smith, both professors at major law schools, published a law review article in 1985 arguing that birthright citizenship for children of undocumented immigrants was not constitutionally required, and that Congress had the power to restrict it by statute without amending the Constitution. Their argument has been cited in congressional testimony, federal court briefs, and Supreme Court opinions. On the other side, the preponderance of constitutional scholarship says this argument is wrong. Wong Kim Ark settled this. The Supreme Court ruled 6-2 that a child born in the United States to parents who were not only not citizens, but who were legally barred from ever becoming citizens, was nonetheless a birthright citizen. If children of people legally barred from the country are citizens, children of people illegally present are citizens too. And beyond the case law, the proponents of birthright citizenship argue that the historical purpose of the amendment settles the question. The 14th Amendment was written to ensure that no American government could ever again decide, as Taney did in Dred Scott, that certain categories of people born on American soil do not belong here because of who their parents were. The whole point of the Citizenship Clause was to take that determination out of government hands entirely. You are born here, you are American. No further questions. Using subject to the jurisdiction thereof to create a new category of people born here who are not citizens would be doing exactly what the amendment was designed to prevent, allowing the government to determine membership in the national community based on parentage. In the first week of his second term, in January 2025, President Trump signed Executive Order 14,160, directing federal agencies to cease recognizing birthright citizenship for children born in the United States to parents who were either undocumented or in the country on temporary visas. Federal judges in 4 separate district courts blocked the order within days. The administration appealed to the circuit courts. The Supreme Court agreed to hear certain procedural questions related to the injunctions. And suddenly, the subject to the jurisdiction thereof, question, debated in law reviews for 40 years, was back in active federal litigation. There is also a practical dimension to this debate that tends to get lost in the constitutional abstraction. The United States Census Bureau estimates there are between 4 and 5 million people living in the United States who were born here to undocumented parents and are currently citizens under existing law. If a Supreme Court ruling were to hold that birthright citizenship does not apply to children of undocumented immigrants going forward, it would not strip those people of their existing citizenship. Retroactive stripping of citizenship would raise a separate set of constitutional problems so severe that virtually no legal scholar advocates for it. But it would mean that children born tomorrow in American hospitals to parents without legal status would not be citizens. It would create a class of people who are born in the United States, who grow up in the United States, whose entire life experience is American, but who legally belong to no country. No citizenship from the country where they were born. And frequently no citizenship from their parents' countries of origin either, since many countries do not automatically confer citizenship on children born abroad. Stateless. Born in America. Belonging legally nowhere. 33 countries currently grant birthright citizenship unconditionally. Most of the world does not. If the United States ends it, it joins the global majority. It also reverses a principle embedded in its Constitution since 1868, written specifically to prevent a government from deciding that certain categories of people do not belong based on who their parents are. The framers of the 14th Amendment knew exactly what it looked like when a government made that decision. They had just finished fighting a war over it. As of 2025, the executive order restricting birthright citizenship has been blocked by multiple federal courts, and the litigation is ongoing. Whether the Supreme Court will directly address the constitutional question of whether the 14th Amendment requires birthright citizenship for children of undocumented immigrants remains unclear. What is clear is that the question is alive in the federal courts in a way it has not been since Wong Kim Ark in 1898. The people arguing to narrow birthright citizenship believe they are being faithful to the original meaning of the 14th Amendment. Senator Howard's explanation on the Senate floor, they say, demonstrates that the framers intended subject to jurisdiction in a complete political sense. They are not, in their view, trying to undo what the amendment accomplished. They are trying to read it correctly, and they make one additional argument worth taking seriously. The facts of 2025 are genuinely different from the facts of 1868 or even 1898. In 1868, there was no such thing as illegal immigration in the modern sense. The category did not exist. The first comprehensive federal immigration restriction was not passed until 1882. The modern regime of immigration enforcement, with its legal distinction between documented and undocumented presence, is a 20th century creation. The framers of the 14th Amendment were not thinking about it because it did not exist. Whether that matters constitutionally is the core of the debate. The people arguing to maintain birthright citizenship say the opposite. They argue that the amendment means exactly what it says, that its history makes any narrowing interpretation a betrayal of its purpose, and that the argument being made today is structurally identical to arguments made before against other groups. In the 1890s, the argument was that Chinese immigrants' children were not really subject to U.S. jurisdiction because their parents owed allegiance to the Emperor of China. The Supreme Court rejected it 6-2. In the early 20th century, similar arguments were made against children of various immigrant groups, whose loyalty was questioned, whose presence was treated as temporary or contingent even when they had been born here. Courts rejected those arguments too. Each time, the argument took a different form but rested on the same underlying claim, that this particular group of people born on American soil is somehow different, somehow not quite subject to jurisdiction in the complete sense, and therefore not quite entitled to the citizenship the Constitution appears to guarantee them. Each time, the courts held the line. Here is what this entire 157-year history comes down to. The founders made a decision in 1787 to leave the citizenship question unanswered, because answering it would have required confronting slavery, and they were not prepared to do that. The cost of that decision was paid over the next 78 years in increasingly severe crises until it exploded into the deadliest war in American history. The generation that won that war answered the question as clearly as they knew how. They wrote all persons born in the United States into the Constitution. They chose the most inclusive language available to them. They chose it deliberately because they had seen what happened when the government was allowed to decide who belonged. The argument being made today is that their language, despite its clarity, does not mean what it says. That 4 words embedded in the citizenship clause create enough ambiguity to permit the government to exclude certain categories of American-born children from citizenship based on their parents' legal status. Somewhere in the United States tonight, children are being born. Some of those children have parents who are citizens. Some have parents who are legal permanent residents. Some have parents on temporary visas. Some have parents whose presence in the country is unauthorized. Under 157 years of constitutional law, all of those children are Americans. Whether they will still be Americans when they grow up is, as of today, a question being argued in federal court. That is the story of birthright citizenship in America. 21 words written in the aftermath of the Civil War, still being interpreted, still being contested, still being fought over in the courts and the Congress of a country that has never fully resolved the question its founders refused to answer. As of 2025, this story is not over, not even close. If this is the kind of history you are here for, subscribe. There is a great deal more of this left to tell. But to understand why that matters, and why the courts may not hold the line this time the way they have before, you need to understand something about the legal landscape that surrounds this question in 2025. Because the argument being made is not just coming from politicians, it is coming from serious legal scholars with sophisticated constitutional theories, and it is being received by a Supreme Court whose composition has shifted in ways that make the outcome genuinely uncertain. Let us go back to that phrase one more time. Subject to the jurisdiction thereof. John Eastman, who served as a constitutional law professor for decades before becoming a controversial figure in other contexts, argued for years that the phrase created a genuine ambiguity. His reading drew directly from Fuller's 1898 dissent. Complete jurisdiction, Eastman argued, required allegiance. And allegiance, in the constitutional sense, was something that could not be assumed just from being physically present within the country's borders. The analogy Eastman and others used was the diplomat's child. Everyone agrees that a child born in Washington, D.C., to the French ambassador is not an American citizen. The ambassador owes allegiance to France, not to the United States. The ambassador's diplomatic immunity is itself an expression of that fact. American courts cannot touch the ambassador because the ambassador is subject to French sovereignty, not American. And therefore, the ambassador's child, born on American soil, is not subject to American jurisdiction in the complete political sense. If you accept that reasoning for the diplomat's child, the argument continues, then you need to ask what makes an undocumented immigrant situation categorically different. The undocumented immigrant entered without authorization. Their presence is not legally recognized. They have not been admitted under any visa category that would signal American acceptance of their presence. In what sense, the argument goes, are they fully subject to American jurisdiction? The counterargument is that this analogy breaks down at the critical point. The diplomat's exemption from American jurisdiction is a formal, legally recognized arrangement. It exists because the United States and France, and every other country in the diplomatic system, have agreed that sovereign representatives of foreign nations will not be subject to local courts. That agreement is the source of the diplomatic immunity, and it is the diplomatic immunity that removes the child from American jurisdiction. An undocumented immigrant has no such agreement. No treaty, no diplomatic status, no recognized sovereign relationship to a foreign power that the United States has formally acknowledged. An undocumented immigrant who commits a crime in the United States can be arrested, tried, and imprisoned by American authorities. They pay taxes if they earn income. They are subject to American civil and criminal law in every ordinary sense. They are, in the most practical meaning of the word, under American jurisdiction. And if they are under American jurisdiction, then their children, born on American soil, are born subject to that jurisdiction. And therefore, under the 14th Amendment, those children are citizens. That is the legal debate in its cleanest form. One side argues that jurisdiction requires allegiance, and allegiance requires legal status. The other side argues that jurisdiction means being subject to American law, which every person physically present in the country is, regardless of their immigration status. 99% of the legal commentary says the second reading is correct. But the cases that matter are not decided by legal commentary, they are decided by the 9 people on the Supreme Court. And in 2025, the Supreme Court includes 6 justices appointed by Republican presidents, several of whom have shown interest in originalist methodologies that ask what a phrase meant at the time it was written rather than how it has been applied since. The question of what subject to the jurisdiction thereof meant to the men who wrote it in 1866 is, genuinely, an open historical question in a way that makes legal analysts more cautious than they would have been a decade ago. There is also a second, separate question buried inside this debate that almost never gets enough attention. It is the question of who decides. Under the current consensus, birthright citizenship is a constitutional right, not a statutory one. That means Congress cannot take it away by passing a law. It would require a constitutional amendment, which requires 2/3 of both houses of Congress and ratification by 3/4 of the states. In the current political environment, that is essentially impossible. But if the Supreme Court were to rule that the 14th Amendment does not guarantee birthright citizenship for children of undocumented immigrants, then Congress would gain the power to regulate it by statute. Congress could choose to grant birthright citizenship, or it could choose to restrict it, depending on the political majority of the moment. A right that had been constitutional would become statutory, vulnerable to repeal whenever the political wind shifted. That is not a hypothetical power shift. It is the central practical stakes of the legal question. Not just who is a citizen today, but who gets to decide who will be a citizen tomorrow. The people who want to end birthright citizenship for children of undocumented immigrants argue that this is exactly how democracy should work. Immigration policy should be set by elected representatives, not by a constitutional clause written to solve a completely different problem in 1868. The voters should decide who gets to be a citizen. The people who want to maintain birthright citizenship argue the opposite. The whole point of constitutional rights is that they are not subject to democratic majorities. Dred Scott was the result of a political system that allowed the question of black citizenship to be answered by whoever held power. The 14th Amendment was designed to take that question off the political table permanently. Returning it to the political table, even under the banner of democratic accountability, is a betrayal of what the amendment was built to do. Both of those arguments are principled. Neither is obviously wrong. They reflect genuinely different views about how constitutional democracy should work, and about the relationship between text, history, intention, and outcome in constitutional interpretation. What is not in dispute is the history. The United States spent the first 79 years of its existence without a constitutional answer to the citizenship question. The cost of that silence was the Civil War. The 14th Amendment was the answer the surviving generation wrote in the ashes of that war. It was written by people who had seen, with terrible clarity, what happened when governments were allowed to decide which human beings born on their soil were truly theirs. The question now is whether that answer still holds. There are people alive today who were born in American hospitals, grew up in American cities, went to American schools, and have known no other country, who are watching this litigation with something considerably more intense than academic interest. For them, this is not a constitutional debate. It is a question about whether the country they have always understood to be their own actually considers them its own. For them, the argument about subject to the jurisdiction thereof is not an abstraction about textual interpretation. It is a question about belonging. And the answer that comes from the federal courts over the next several years will tell them, and the rest of the country, what kind of answer the 14th Amendment actually provides. Whether its 21 words mean what they say, or whether 4 of those words contain enough ambiguity to permit a government to do, in a different era with different targets, what Roger Taney did in 1857. Taney thought he was settling the question too. He thought he was reading the founders correctly. He thought he was protecting the Union. He was wrong about all of it, and 620,000 people died before the country corrected the error. The courts that are hearing these cases now know that history. The lawyers arguing both sides know it. The justices who will eventually rule know it. Whether they are guided by it is the question that remains. That is where we are in 2025. A constitutional amendment written 157 years ago to answer a question the founders refused to ask, being tested by a set of circumstances the amendment's authors could not have imagined, in front of a court whose answer nobody can fully predict. The story of birthright citizenship in America is not a story that has ended. It is a story in the middle of its next chapter. And what gets written in that chapter will shape what kind of country this is for the people who are being born into it. Right now, tonight, in hospitals across the United States, to parents of every legal status and every national origin, on soil that has called itself the land of the free for 2.5 centuries. 21 words, written in 1868, still being argued over in 2025. That is the story, and it is not over. To fully understand what is happening in 2025, you also need to understand the legal machinery that makes this moment different from every previous moment in the birthright citizenship debate. Because this is not the first time politicians have tried to end birthright citizenship. It is the first time a sitting president has issued an executive order attempting to do so. And the question of whether a president can do that, independent of Congress and without a constitutional amendment, is itself a major legal controversy that has not yet been resolved. The executive order that Trump signed in January 2025 directed all federal agencies, including the State Department and the Department of Homeland Security, to stop recognizing birthright citizenship for children born to undocumented parents or parents on temporary visas. That is an extremely broad category. Temporary visas include student visas, work visas, tourist visas, someone who is in the United States entirely legally, who has violated no law, who is paying taxes and following every rule, but who is here on a temporary basis rather than as a permanent resident or citizen, would have their American-born child denied citizenship under this order. Within hours of the order being signed, federal judges in Washington, Massachusetts, New Hampshire, and Maryland issued temporary restraining orders blocking it. One federal judge, John Coffenor of the Western District of Washington, called the order blatantly unconstitutional, one of the more extraordinary statements a sitting federal judge makes in a written order, and one that signals just how clearly the district court-level judiciary reads Wong Kim Ark and the 14th Amendment. But district court judges do not have the final word. The administration appealed. The cases went to the circuit courts. And the Supreme Court, in a preliminary ruling on the scope of nationwide injunctions, signaled that it intended to weigh in on the bigger question before the litigation was finished. The nationwide injunction issue is itself legally important. A nationwide injunction, issued by a single district court judge, blocks a federal policy everywhere in the country simultaneously. The Trump administration argued that district courts lack the authority to issue injunctions that broad, and that any injunction should only protect the specific plaintiffs who brought the case. The Supreme Court has been skeptical of nationwide injunctions in other contexts, and if it limits their scope in the birthright citizenship cases, it could create a situation where the policy is blocked in some jurisdictions and operative in others, meaning whether a child born in Massachusetts is a citizen could be legally different from whether a child born in Texas is a citizen, depending on which circuit court's ruling is in effect. That would be a deeply unstable legal situation. Constitutional rights are not supposed to vary by geography inside the United States, and it would create enormous practical chaos since the federal government issues a single type of passport and a single type of social security number and does not generally operate different citizenship regimes in different states. The Supreme Court will ultimately have to resolve this. The only question is when and on what grounds. There is one more dimension to this story that has not gotten enough attention in the public debate. That is the international dimension. The United States is a signatory to the 1954 Convention relating to the status of stateless persons and the 1961 Convention on the reduction of statelessness. These international agreements commit signatory states to avoid creating conditions that would render people stateless. The United States has ratified both. If the federal government ends birthright citizenship for children of undocumented immigrants going forward, and if those children's parents' countries of origin do not recognize them as citizens because they were born abroad, those children would be stateless. Born in a country that says they are not citizens, and holding no citizenship from any other country because their parents' nationality does not automatically transfer to children born outside the country. International law does not simply override American constitutional law. The Supreme Court has been clear about that. But the international commitments the United States has made create diplomatic and legal context that courts consider, and they are part of the backdrop against which any ruling would be evaluated by the international community. The United States' standing in international forums, its relationships with countries whose nationals would be most directly affected, and its reputation as a country that honors its legal commitments are all at stake, in ways that go beyond the immediate constitutional question. None of that is determinative. American courts will decide this question on American law, but the idea that this is a purely domestic debate with no international implications is wrong, and anyone who tells you otherwise is missing a significant part of the picture. Let us also talk about what ending birthright citizenship would mean in practice, on the ground, in American hospitals and courtrooms and government offices, if the Supreme Court were to rule against it. The moment a child is born in the United States, the hospital issues a birth certificate. That birth certificate is currently the foundational document of American citizenship. It is used to apply for a social security number, for a passport, for enrollment in public schools, for every government benefit and legal recognition that American citizenship provides. The birth certificate does not currently ask about the parent's immigration status. It records the fact of birth on American soil. If birthright citizenship ends for certain categories of children, the birth certificate becomes insufficient. The child's parents' immigration status would need to be verified and recorded at the time of birth. Hospitals would become, in effect, immigration enforcement checkpoints. Every maternity ward in the country would need protocols for verifying parents' legal status and recording it on official documents in ways that determine whether the newborn child has citizenship. The administrative apparatus required to implement this would be enormous. The potential for error, for fraud, for discrimination based on who looks like they might be undocumented is significant. The civil rights implications of requiring hospitals to conduct immigration status checks on new parents are substantial. And then there is the question of what happens to children who are denied citizenship at birth as they grow up. They would live in the United States because their parents are here. They would go to American schools under the Supreme Court's ruling in Plyler v. Doe in 1982, which held that children of undocumented immigrants have the right to public education regardless of their immigration status. They would grow up speaking English, knowing no other country, having no connection to any other place, and they would have no path to citizenship because the path that every other person in their situation has had for 157 years would be closed. This group of people would grow over time. They could not vote, they could not hold most government jobs, they could not obtain federal student loans, they could not serve in the military in most capacities. They would be a permanent underclass of people who are American in every cultural and practical sense, but who are legally foreign in their own country. The closest analogy in American history is the situation of free black Americans before the Civil War, who were legally non-persons in a country they had been born and raised in. The 14th Amendment was written specifically to make that impossible. Whether it succeeded in making it impossible is now, again, the question in front of the courts. The people who support restricting birthright citizenship argue that this comparison is unfair. The situation of free black Americans before the Civil War was the result of slavery, of racial oppression, of a system that denied humanity to people based on race. The situation of children of undocumented immigrants, they argue, is different because it is a consequence of their parents' legal choices, not of their own race or identity. That argument has some force. The legal and moral situations are not perfectly analogous, but the structural result, a class of people born on American soil who are legally not citizens of the country they were born in, is the same. And the question of whether the 14th Amendment permits that result is the same regardless of the reason it is being attempted. The amendment says all persons. It does not say all persons, except those born to parents who entered the country illegally. It does not contain exceptions based on the legal status of parents. If exceptions of that kind are going to exist, they will have to be read into the text. And reading them in requires explaining why the men who wrote all persons really meant something more limited than all persons. That is a difficult argument to make in light of the history. The men who wrote the amendment had just watched a Chief Justice of the Supreme Court take the word people in the Constitution and argue that it excluded black Americans, despite the fact that black people had been present in America since before the Constitution existed, had fought in its wars, had helped build its cities, and had in many cases been born on its soil. Taney's argument was that the founders had not meant to include them, that despite the broad language of the text, the true intention was narrower than the words. The framers of the 14th Amendment chose all persons precisely because they did not want future interpreters to do what Taney had done. They wanted language so broad that no future court could carve out exceptions based on who the government of the moment wanted to exclude. Whether they succeeded is the question the courts are deciding now, and whatever those courts decide will become part of the same long chain of decisions about who America is for and who gets to say. That chain started with the founders who wrote citizen 11 times without defining it. It ran through Dred Scott and the Civil War and the 14th Amendment and Wong Kim Ark and a century of immigration debates and restriction laws and court decisions. It runs through the federal courthouse hallways where lawyers are arguing about it right now. And it will run through the lives of every child born on American soil tonight and tomorrow and the night after that, who will grow up to discover what the country decided about whether they truly belong here. This is the kind of history that never really becomes the past. It is the kind of history that keeps producing the present. If you want to keep following it, subscribe. There is more of the story ahead. One last thing before we close, and it is something the legal debate almost never addresses directly. There is a version of this conversation that treats birthright citizenship as a purely technical question, a matter of textual interpretation, of historical meaning, of what 4 words written in 1866 were intended to accomplish. That version of the conversation is important. Courts have to engage with it, lawyers have to argue it, and the outcome of that technical argument will have real legal consequences. But the reason this conversation generates so much heat is not because Americans are deeply passionate about the original public meaning of jurisdictional clauses in post-Civil War amendments. The reason it generates heat is because it is a conversation about who belongs here. Who is one of us? Whose children get to grow up as Americans? That question has never been easy for this country. America has always been a nation of people who came from somewhere else, who were brought from somewhere else, who were here before anyone else arrived. The project of deciding who counts as American has been ongoing since the founding, and it has never been resolved cleanly or finally. The 14th Amendment was the most ambitious attempt in American history to resolve it. All persons born here are citizens. No exceptions for race. No exceptions for the status of parents. Born here, you belong here. For 157 years, that principle has held, imperfectly and with ongoing contestation, but held. Children born in American hospitals have grown up as Americans. They have voted. They have served in the military. They have run for office. They have become the next generation of the country that was born on their birthday. Whether that continues is now genuinely uncertain in a way it has not been since the 19th century. The courts will decide the legal question. The political system will respond to whatever the courts decide, and the country will live with the result. But it is worth remembering, as this unfolds, what was at stake the last time America decided to let its government sort through the people born on its soil and decide which ones truly counted. It took a constitutional amendment to undo that decision, and it took a war to make the constitutional amendment possible. The 14th Amendment was not a gift from an enlightened government to its people. It was a demand, written in the immediate aftermath of catastrophic violence, by people who had learned at enormous cost what happened when the government was trusted to decide who belonged. That is the history, that is what is being tested, and the answer, when it comes, will say something important about what kind of country America is in 2025, and what it intends to be for the people who will be born into it in 2026 and 2036 and 2056, 21 words, 157 years, still counting.